Hello, everyone, and welcome to this week's iteration of ELI Summer School. Today, we're going to be focusing on the Clean Water Act. If you're interested in the full list of events that are a part of this series, please go to ELI's event page, and you should be able to find that as well as many other things that are going on this summer through the Environmental Law Institute. So I'm Adam Schemp. I'm a senior attorney at the Environmental Law Institute, focusing on water issues, water quality, water allocation, and to some degree, oceans and coastal issues. I do quite a lot of work with the 303D program at EPA, and you'll learn more about that in the coming 2 hours. But today I'm mostly going to be serving as a moderator for this panel. We are very fortunate to have John and Kelly with us today. We're going to start with a brief overview of the history of the Clean Water Act by John Mueller, followed by a deeper dive by Kelly Moser into one of the most written about issues within the Clean Water Act, and that is the waters of the US rules. As a quick programming note before we get started, please send in your questions while the presenters are talking. You'll see in your right hand, in the right-hand column there, sort of the dashboard for GoToWebinar. There will be an opportunity to put your questions in the chat box. Just please type them in as you have them. We'll be organizing them, and we'll try to make the Q&A as efficient as possible when we get to that stage. But it'll be really helpful for us to have them in advance and try to organize them. And to the extent that there are some repeats or whatever, we can try to bump those questions up to the top, knowing that they are big issues for all of you. I can't promise that we're going to get to all the questions today, but we will try to get to as many as we can. And that process will help us try to accomplish that. So our first presenter today is John Mueller. He is Vice President of Litigation at the Chesapeake Bay Foundation. He joined CBF in 2004 as the organization's first Director of Litigation after serving 17 years as a trial and senior attorney in the Department of Justice's Environmental Enforcement Division. John has been CBF's Vice President of Litigation since 2009, during which time he developed CBF's Litigation Fellowship Program and Environmental Justice Attorney position. He also sits on CBF's Diversity, Equity, Inclusion, and Justice Committee. John earned his law degree from the University of Richmond and his undergraduate degree in biology from the College of William and Mary. He is licensed to practice in DC, Maryland, Pennsylvania, and Virginia, and he is a member of the District of Columbia 3rd and 4th Circuit Court of Appeals and the US Supreme Court. He teaches as an adjunct professor at the University of Maryland Law School. And without further ado, John, the floor is yours.
Hello, everyone. Thank you, Adam, and thank you, ELI, for inviting me to participate and try to share a little bit of the knowledge I've gained over the, I guess, 30 years I've been doing this. You know, I think one of the things you'll learn today is that sounds like summer school, and summer school maybe can be more relaxed. But I kind of view it more or less as a boot camp, because we're going to go pretty fast through some pretty complex topics. And, you know, as Adam said, I teach as an adjunct at Maryland during the fall, and it's a Clean Water Act seminar, and it's a 12-week course. So you're going to learn 12 weeks of Clean Water Act in a couple of hours. So I apologize if some of these topics don't seem to be covered as thoroughly as you would like. By all means, you know, ask questions, and Kelly and I will definitely try to answer them as best we can. So I'm noticing there's a little lag with my PowerPoint, so hang on. There we go. So I'll give you a roadmap where we're going today. For my portion, I'll be giving you a little background and purpose of the Clean Water Act, some key definitions. The kind of high points of the Act are most certainly the permitting sections. You know, a lot of people talk about how the Clean Water Act deals with point sources and non-point sources, and doesn't deal that effectively with non-point sources, which I agree, but there certainly are components of the Clean Water Act that address non-point source pollution, and we'll get into those terms. We'll then also talk about Clean Water Act water quality standards and Section 303D. One of the things you'll notice here is that I'm talking about sections, and I'm using kind of the bill or legislative number as opposed to the code numbers. Tried to give those section numbers as well along the way, but typically people, when they talk about the Clean Water Act, they use the sections like 402, but not 1342. Then we'll talk real quickly about water quality certification, section 401, and then the enforcement sections for both government and citizen suit. So Kelly goes into this a little bit more detail about the Rivers and Harbors Act. It was kind of the precursor, the original U.S. statutory provision that controlled navigation mostly and hazards to navigation within the United States. And Section 10 waters, you'll hear about that. And those are kind of the traditional navigable waters that Kelly will get into. But mostly we're talking about, barges trying to go up and down rivers. And then they realize, well, hey, those barges actually leak stuff and cause pollution. How do we address that? Well, the Act doesn't really address it. So we came up with this Act of 1948, talked about pollution abatement if it was economically feasible. And then people began to realize in Congress that, well, maybe that limitation really isn't a great idea, because here we have, the Cuyahoga River catching on fire a number of times, and it's not the only, trigger for Congress to finally act, but it seems to be the one that kind of kicked everything off. And then in 1972, we finally got a more, what I call, modern Clean Water Act. It's certainly been amended a few times. You see Richard Nixon here signing the act. I've never quite figured out why he's smiling, because it was done pursuant to a congressional veto override. But anyway, he was always kind of a smiling guy. So we go into a little bit of the congressional goals and policies in the Act. So Section 101 addresses those, and you'll see right off the bat that the primary objective was to restore and maintain the chemical, physical, and biological integrity of the nation's water. So pretty broad in scope. Now you'll then see the national goals and the interim goals. The national goal was eliminate the discharge of pollution altogether by 1985. And then we have the interim goal that will protect water quality for the propagation of fish, shellfish, and wildlife, and also protect recreation by July 1st, 1983. I think everyone on this video webinar is probably aware that we didn't get there. And so we're kind of still working to try and attain those goals. That does not mean that the goals are not attainable, but there are some internal conflicts within the Act, and we'll see as we go through the permitting sections that, in fact, the Act allows the discharge of pollutants subject to permitting. So, these national goals are very broad in scope. They use very broad language in writing it. We on the environmental side like to always remind the reviewing court that that's where we're coming from. But they recognize that there are some inherent contradictions within the Act, and just in the way our economic system works, how development works, the whole aspects of air pollution causing water quality problems, not something originally addressed in the Act. So we'll see the evolution of the Act as we go through these sections. Also, one thing I always remind my class is that there's a pretty extensive set of regulations that go along with implementation of the Act. And EPA, for the most part, and you'll hear in a little bit, the Army Corps of Engineers has also written provisions concerning the definition of waters in the United States. So always, read the statute, by all means, understand its definitional terms and the policies and goals, but remember that there are also regulations out there that govern operations of sources of pollution that discharge to waters. that's another thing I meant to remind folks at the beginning. We're talking about discharge to surface water for the most part. We're not dealing with drinking water. That's a whole separate statutory provision. Although we'll see as we get into the County of Maui discussion that in fact there can be discharges to groundwater that can be considered point sources if they then also discharge to surface water. So the national policy, again, eliminate the discharge of toxic pollutants here. And as I mentioned earlier, folks kind of think of the Clean Water Act as really only addressing point sources, but Congress recognized the contribution that non-point sources have to water pollution. So the EPA was directed to develop and implement programs to control non-point source pollution so the goals of the Act can be met. One of the other kind of overriding policies of Congress is to recognize and preserve and protect the primary responsibility of the states to prevent, reduce, and eliminate pollution. And then later on in the same section 101, you'll see federal agencies are directed to cooperate with the state and local agencies to reduce pollution. And so we come into this phrase of cooperative federalism, and we'll hear a lot of that in the TMDL section, but it carries over to other sections as well as permitting, where the states actually have an active role to play. It's not all the federal government. We'd like to look at the Act as kind of the floor, and if states want to do more, they can actually write their own provisions into state law or regulation. So again, we're talking about the Clean Water Act, about the federal statute, federal regulations, but you need to remember that there are also state laws that oftentimes govern discharges of pollution into water or dredge and fill of state waters. So please be mindful of that as well. So if we turn to section 301 of the Act, basically that provision boiled down says, well, you're allowed to discharge pollutants if you do so subject to these other provisions, and the two that I'm going to talk about today are section 402, which address point source pollution, and section 404, which is the dredge and fill or wetlands aspects of it. While I talk about those definitional terms, Kelly's pretty much kind of focusing on the scope of 404 and the sense of what's the jurisdiction of the Clean Water Act under the Waters of the U.S. definition. So again, here we have the discharge of pollutant is unlawful. All right, so what is a pollutant? Some examples that the Act gives are dredge spoil, sewage. This is the Blue Plains facility outside on the border of DC, and controls sewage in Maryland, DC, and Virginia. It's the largest wastewater treatment plant in the world. We also talk about industrial sources of pollution. This is the former Bethlehem Steel, Sparrows Point steelmaking facility at the mouth of the Patapsco River in Baltimore. Pollutant also means solid waste, incinerator residue, garbage, munitions. Yes, you can't drop bombs into water, and there are actually cases that cover this. The Vieques in Puerto Rico, a bombing site for the U.S. Navy. Chemical waste, biological materials, radioactive materials, heat, rock, sand, and cellar dirt of all things. So if you're doing some excavation this summer, remember to make certain you need a permit for your cellar dirt disposal. Again, look at the statute and the regulations for these definitional terms. So it says discharges of pollutants are unlawful. And so that phrase is defined as the discharge from any point source into navigable waters or the ocean. Well, what are navigable waters? Waters of the United States, including the territorial seas. Really helps you understand the scope of the act, and Kelly's going to cover this in much more detail. And so what is a point source? Any discernible, confined, and discrete conveyance from which pollutants are or may be discharged. So discernible, confined, and discrete conveyance. So that can be a pipe. Again, Sparrows Point had its own wastewater treatment facility for industrial operations for its tin mill and other steel making processes at the plant. So mostly oil and grease discharge here from its wastewater treatment facility into Bear Creek and Tapsco River. And then we have some cases that have defined this term as well. So we have the phrase tunnel, and this is a view on the left of the Shockenden Tunnel in the Catskills of New York. That case has gone up and down a couple of times, and I think EPA even tried to write a rule to address this issue of how water going into a tunnel meets water quality standards going in, but for some reason doesn't when it leaves, and they could not quite figure it out. So a lot of fussing around trying to figure out how to save the city of New York having to address this problem. And then on the right, you'll see pesticide spraying. So the National Cotton Council case dealing with spraying from airplanes over cropland that goes directly to navigable waters. Conic Baykeeper, you have backpack spraying, same thing. There was a need for a point source discharge permit under the Clean Water Act, even though there's already Federal Insecticide and Rodenticide Act provisions that control that pollution from pesticides as well. Point source has also been found to be a coal loading or conveyor. Here, this is the Aurora Energy Services facility in Alaska. We have construction stormwater, the runoff from construction sites. And then we have concentrated animal feeding operations, dairy facility on the top left, hogs in the bottom, and of course poultry on the right. All of these sources of pollution, mostly manure, but we also have ammonia into the air that is now contributing problems with nitrogen pollution in the Bay region, for example, because that ammonia goes into the air. It contains nitrogen, ends up in the water, and nitrogen is a pollutant in the bay that is causing problems, as we'll talk about it more directly a little later. And then we have urban stormwater, and you can see from this diagram there are a lot of different ways when it rains where pollution can come from within your city or town. And most notably, a lot of these older systems on the East Coast were designed to carry sewage and stormwater, the combined sewers, which have led to tremendous problems with fecal coliform and E. coli bacteria discharged directly into sources of fishing, swimming, shellfish propagation, that sort of thing. So again, there can be permits for municipal separate storm sewers. Those are mostly for urban areas, and those are pretty complicated based on the community, the size of the community, the types of discharges, sources where they're coming from. So a kind of an area of the law that's continuing to develop. Again, some other definitions of point source include a ditch, a channel, a conduit, a well, which again is interesting because now we're discharging into groundwater, and we'll talk about that County of Maui in a little bit. A discrete fissure, a container, rolling stock, a vessel, or other floating craft. But remember that a point source does not include agricultural stormwater discharges. So you'll see here on the left, runoff from a farm field, livestock operation, or return flows from irrigated agriculture. So if you've ever been driving through the farmland and you see these gigantic sprinklers on wheels, for example, they're irrigating the cropland. Sometimes they over irrigate or they're using irrigation canals. That water actually can run back into receiving stream or river and not require a permit. So here we have section 402, which is the primary permitting section, National Pollution Discharge Elimination System. Some people say NPDS, others say NPDs. I never got the hang of that one, so I stick with NPDS. Here, the administrator is authorized to issue a pollution discharge permit. So again, beginning we had, and the act says no discharge of pollutants. And here we have, oh, well, you can if it's okay by the administrator and public is given notice and opportunity to comment and the permit's issued. However, the discharge has to meet all applicable requirements of other provisions of the Act, like water quality standards, for example, and that's where a state will identify what it thinks the water quality should be in its bodies of water, and then how do you attain those standards or preserve those standards for fishing, swimming, shellfish propagation, that sort of thing. Or the administrator, EPA, adds conditions to the permit that are necessary to meet the other provisions of the Act. As I said before, states can administer permits. They have to seek delegation from the EPA administrator and show that they're going to comply with all the provisions of the federal act. And it has to be attested to by the Attorney General for that state that they are going to provide all the same public notice and comment provisions and enforcement provisions that the federal government would do. EPA gets to review those and then decide whether to delegate that authority for permitting. EPA has the authority to withdraw that delegation if it determines that later a state is not living up to its obligations, but that is pretty difficult to do and has not happened often. So one of the more recent issues that's come up about this discharge to groundwater that then flows out to surface water. In the case that went up to the Supreme Court, was decided last year, County of Maui versus Hawaii Wildlife Fund. The city of Maui operated a wastewater treatment facility, and it was actually permitted to discharge into groundwater, but it did not have an NPDS permit, and it was later determined through offshore monitoring that the injection wells were actually being taken up by groundwater and going offshore. They tested the water and found through dye tracing and other things that there was a direct connection from the injection wells to surface water. And the Supreme Court there determined that these wells acted as the functional equivalent of a point source. And there's been a lot of talk about what does functional equivalent mean. The Supreme Court gave 7 factors, I believe, that identified what that meant. EPA then came out through the Office of Water and came up with some kind of guidance, policy guidance, that a lot of people objected to because it seemed that the agency was actually ignoring certain provisions that the Supreme Court found were important, or factors the Supreme Court found important. So the Biden administration has been asked to withdraw that guidance, and I know it's going through that process now. But one of the more contentious areas of groundwater discharges have to do with coal ash pits are coal ash ponds. When you burn coal, it doesn't all completely go up into the air or turn into energy. There is residual ash that's left over, and traditionally coal-fired power plants dump that ash into a lagoon or a pond or a pit. Those filled up with water, and lo and behold, they now have a surface water contact. So there's been a lot of question within the circuits, federal circuits, as to whether those coal ash ponds are actually point sources. And so some circuits said they were, others said they weren't, and there's been a decision by the Supreme Court and the most recent case to have looked at this issue after County of Maui is this Prairie Rivers Network case versus Dynegy Midwest Generation out of the Seventh Circuit. It was argued late last year, and to my knowledge, there hasn't been a decision yet. Now we'll shift over to the dredge and fill permitting provisions of the Act. This is, basically what people talk about: wetlands, dredge and fill. So, we talk about dredge spoil as a pollutant. Here we also have dredge and fill of wetlands. So here you can see this is actually from the Rapano site that Kelly's going to talk about in a little bit, where he came in with an excavator and cut down all the trees and then dug a ditch to drain the water off so he could build homes. But you need a permit to do it. And as Kelly will explain, Mr. Rapano's decided he didn't need one. One of the things that is also important to know here is that this is where the Army Corps of Engineers actually issues these permits. States will have permitting authority under this provision as well as Section 402. But EPA kind of has an oversight role to play as well to make certain that there aren't going to be adverse impacts to natural resources and water quality. And so EPA was directed by Congress to identify what are called 404B1 guidelines. And so you need to go and look at the regulations for those guidelines when you're reviewing a permit to make certain that it complies with those provisions. We got involved with the Chesapeake Bay Foundation along with Southern Environmental Law Center. I have to say, put a plug there for Kelly's organization. We challenged the city of Newport News permit that was granted by the Army Corps of Engineers to fill in 427 acres of wetlands to build a drinking water reservoir that would then pump water down to the city of Newport News for drinking water. We were able to challenge that decision by the Army Corps and the DC District Court, and the DC District Court found in our favor, saying that the Army Corps had not followed 404 B1 guidelines, nor had it followed Section 404 with respect to other aspects of its decision. When that happened, the city of Newport News miraculously found it didn't need all that drinking water anyway. So to my knowledge, it's one of the largest wetlands permits, at least in the state of Virginia, that we were able to overturn. The next provision I want to speak about is what's called the Water Quality Certification, Section 401 of the Act. So any project that requires a federal license or permit, or a federal highway, a natural gas pipeline, for example, it has to receive a certification from the state where the project is going to be built or operate, that the operation of or construction of this project is not going to harm water quality. Then some recent decisions, most notably out of the state of New York, where it denied water quality certification for the Constitution pipeline, and that pipeline was effectively blocked because it could not, or the company could not establish to New York's satisfaction that its construction and operation of the pipeline was going to protect water quality in the state. One of the bigger decisions that's come out of the DC Circuit Court has to do with the provision of the statute that says that the certification has to come within 1 year of the application. And there have always been some questions about, well, how long does 1 year really mean? Can we extend that 1 year period by agreement if we don't think the application is complete enough? Or we in the state agency need to do some more investigation to see exactly what the harm might be to local water quality. Well, the DC Circuit came back and admittedly in response to some rather, we think, extenuating circumstances where FERC kept granting this extension for tens of years and didn't seem to be really making any progress in getting the information it needed on the application. So instead of just denying certification outright, it kept doing these 1 year extensions, which FERC found the DC Circuit found violated the act. This has caused kind of, sorry for the pun, ripple effects throughout other 401 certification decisions. Most notably for us anyway, in the Bay region has been the operation of the Conowingo Dam by Exelon. It sought a 401 certification from the state of Maryland, which originally was denied. Exelon sued, probably filed 8 different lawsuits challenging MDE, the Maryland Department of Environment's decision to do that. And they ultimately decided to settle the case because of the Hoopa Valley decision, because the Maryland Department of Environment sought and got an extension to do further study on whether the dam was actually contributing sediment and other pollutants to impact Maryland water downstream of the Conowingo Dam, which is on the Susquehanna River, so one of the largest sources of pollution to the Chesapeake Bay. And what the study determined was that in large storm events like the one in this picture, all of the sediment that built up behind this dam over years is actually now being discharged, in large storm events like tropical storms or hurricanes. And so MDE sought to put conditions on the permit, but because of the Hoopa Valley decision and because the state had actually gotten an extension on the application time period, they decided to settle the case. That is now in front of the DC Circuit Court pursuant to a challenge by Waterkeepers, Earth Justice, and the Chesapeake Bay Foundation. So now we'll turn to the total maximum daily load or water quality standard section of the Act. Section 303 requires states to identify water quality standards for all waters within its jurisdiction. And that's to say, this is for fishing, this is for swimming, this is a drinking water supply, and actually identify what kind of fishery. Is this a cold water fishery, or these tier 1, tier 2 type waters that are pristine, we need to really protect, or are these ones that are already degraded when we started to look at them and we really can't get them up to standards that we would like, so they may be at a lesser standard. But if the state identifies this as a source that's been impaired by something, like either non-point source or point sources, they have to identify a total maximum daily load, or TMDL, which is essentially a diet for that body of water. This is the pollutant, and it comes from point sources, which is the waste load allocation. Plus, we see some non-point sources here, farm runoff, for example, that are contributing to the impairment of this body of water. There could be other sources, including natural background runoff, something that's scoured from the bottom of the river or stream itself. And then because Congress and EPA recognized that there was some qualifications and the science of how accurate it is that it's, well, this much nitrogen, 100 pounds of nitrogen is actually causing this algae bloom downstream, but we have to give ourselves a margin of error, a margin of safety for that. So we're actually going to say, well, it's 90 pounds we need to drop it down to make certain that we meet water quality standards. So like other provisions of the Act, we didn't attain the elimination of all pollution by 1985 or 1989 even for that matter. As part of the TMDL program was kind of put on the back burner. This identification of impaired waters was delayed by the states, and consequently the development of TMDLs and their implementation were also delayed or just not even undertaken. So citizens began suing EPA under a theory of constructive submission, which basically said, you've had all of these years to receive applications from the states to identify their impairments. We know these waters aren't meeting water quality standards, and you haven't developed TMDLs for them. So under the statute, EPA, you're required to actually write the TMDL for the state. So some of the more important ones, I think the first case there, Scott v. Hammond out of the 7th Circuit, was the first to really truly identify this theory of constructive submission and direct EPA to actually write a TMDL for the state. And this kind of had a cascading effect through other jurisdictions. The biggest case for us in the Bay region was the American Canoe decision out of Virginia that basically said, if the state doesn't identify all of these impairments, I believe is within 10 years or so, then EPA, you have to do it. And one of those bodies of water was the Virginia portion of the Chesapeake Bay. So I'll talk a little bit about the Chesapeake Bay TMDL. The problems there, the pollution sources are nitrogen, phosphorus, and sediment. They come from all the variety of rivers and streams that feed the 64,000 square mile watershed that is the Chesapeake Bay region. And this contributes primarily to algae blooms, although we also have a sediment problem that smothers aquatic benthic organisms that are sessile. That means they can't move. Oysters, clams, underwater grasses that are essential to bay productivity. These algae blooms lead to dead zones, areas where the bay is anoxic or hypoxic. And you can see here from back 2010, 2012, where those stretches are. Typically in the summertime, this happened, and it just continues to happen because of this contribution of nitrogen, phosphorus, and sediment from the 6 watershed jurisdictions within the Bay region. And that hypoxia or anoxia causes fish kills. This is just a creek not too far from my house, actually. So in 2009, Chesapeake Bay Foundation joined with some people, some elected officials and others, Anthony Williams at the bottom, DC Mayor, former Governor Harry Hughes on the right, Virginia Secretary of Natural Resources Taylor Murphy in the middle, and Senator Bernie Fowler, who does the Patuxent water wade-in every year. I just understand he just did it to see if you can see his tennis shoes in the Patuxent River as he wades out, and you can tell by how far out he goes how the bay is doing, or at least the Patuxent River is doing. And unfortunately, I think this year he was not seeing as well as he did last year. I believe that Senator Fowler is 94 years old, and he still does this, which is a testament to his perseverance and love for the bay. We joined with other sport fishermen and the Maryland and Virginia Watermen's Associations in suing EPA, saying they needed to develop a TMDL for the Chesapeake Bay. In addition to 303, there's another provision of the Act 117G, which we said obligated EPA to take a leading role here, because again, we've got 6 jurisdictions that are contributing to this problem. Individually, they can't fix it. It's a collective problem. They all recognized they were contributing to it, and they asked EPA to actually undertake action to do that. And so in 2010, EPA issued the Bay TMDL, actually came out and published in January 5th, 2011. The Farm Bureau promptly sued and challenged EPA over, along with home builders and a number of other agricultural lobby groups, challenged that decision and said it was illegal. The Middle District of Pennsylvania disagreed, as did the Third Circuit. The case was, cert was sought, but was later denied. So I'll try to go rather quickly here through the provisions, enforcement provisions of the Act. Section 309 of the Act directs the administrator to actually bring civil or criminal actions. All these actions, when they appear in court, the Justice Department actually represents EPA in court. So these referrals for civil actions can be, or criminal actions are made for an EPA to the Justice Department for prosecution. The state is also supposed to be informed that there's a violation within its jurisdiction, especially if it's got its own Clean Water Act and is trying to comply as a delegated state. It's directed to participate. If they don't, then EPA can go forward. The Act sets the range of penalties that can be assessed against a violator for a permit violation, for example. One of the more notable decisions is knowing endangerment that came out of the BP Deepwater Horizon oil spill case. And then there's a specific reference to the wrongful introduction of pollutants into treatment works. And the first case to be prosecuted there was U.S. v. Dissler out of Louisville, Kentucky, in which Mr. Dissler told chemical companies that he could take all their solvents and burn them in a incinerator, although he didn't have a license to operate the incinerator and was directed not to burn the solvents. So he stored them all. Realizing he had too many, he decided to take a tanker truck and drive over the top of a municipal storm drain and discharge the solvents into the storm drain, which he thought would go undetected. Unfortunately, someone lit a match and unfortunately blew off all the manhole covers for miles around and disabled the city of Louisville wastewater treatment plant. He was criminally prosecuted and I believe got some jail time as well as a penalty for that. One of the other provisions of the Act that can be a little confusing is there's an oil and hazardous substance liability provision, and there's a separate provision called OPA, the Oil Pollution Act. You need to recognize that there are differences between those. I'm just going to talk about the oil and hazardous substance liability provisions here. Primarily, if you've discharged, I operate a tank farm that stores oil or diesel fuel or something like that, and hey, I got a leak. You've got to respond and identify the problem, tell local authorities, and direct it to EPA. There's a thing called the National Contingency Plan that identifies who is supposed to get these notifications. So if you operate a facility like this, you should know who you got to notify. If you don't notify and you discharge a hazardous substance or a large quantity of oil, like what happened in Deepwater Horizon, you can receive a substantial penalty. Direct you to kind of look at the magistrate's decision in the Deepwater Horizon case when there was a loss of life in addition to tremendous natural resource damages, and the magistrate's review of the radio transmissions back and forth from the Deepwater Horizon station itself with Houston and the decisions to go forward with that operation. A pretty chilling conversation, and why the magistrate there and the court itself, district court, felt that there was gross negligence in operation by BP. One of the other big things that's part of this provision of the statute, or what are called natural resource damages. Again, I mentioned the National Contingency Plan. It identifies the trustees for certain types of natural resources, marine mammals, fish, birds. It might be the Department of Interior, it might be Department of Commerce, it might be a state agency, it might be a federal tribe. And so these trustees may say, well, look, your oil pollution wiped out 1,000 birds and 150 fish or mammals, marine mammals. These all contributed services to the natural resources, water quality, and we have to restore those sources. And so you can be hit for response costs in addition to natural resource damages. So the provision that originated this, or the action that originated this provision of the statute, I should say, was primarily the Exxon Valdez spill up in Alaska, the top left there, still dealing with oil pollution today, even though this happened almost 30 years ago. Deepwater Horizon on the right. One of the cases I dealt with when I was at DOJ was the Montrose DDT discharge from the Hyperion wastewater treatment facility just north of LA. That wastewater treatment plant discharges about 12 miles out into the Palisfield Shelf off the coast of LA, right at the near the Channel Islands. And Montrose manufactured DDT, and so it discharged its waste in the wastewater treatment system that then went into the wastewater treatment plant and then went out into the ocean. DDT was harmful to birds primarily. It extirpated bald eagles, peregrine falcons, and a lot of pelicans and other birds from those islands. We prosecuted Montrose and its successors for that pollution. I handled the natural resource damage part of the case for birds, and pretty amazing effort by some researchers and scientists that were doing a lot of this unpaid to try and determine the source of the pollution, the extent of the pollution, how many bald nests were actually lost, how many peregrine falcons were lost, for example. Went to trial in LA after the first day of trial, and the recognition that they were not going to get by us. They settled the case, and I believe it was close to $40 million in natural resource damages for restoration of bald eagles and peregrine falcons. You can go to the Department of Interior website that's set up for this. Fish and Wildlife Service has webcams for bald eagles out there. It always amazes me the number of people that are up in the middle of the night watching bald eagles hatch eggs. But it's a great testament to our ability to restore resources that have been damaged through discharge of hazardous pollution. Again, real quickly, citizens can actually file suit of their own. EPA or state doesn't act. The citizens have to give the state, for example, if it's the permitting authority, a 60-day notice. You have to identify in your notice letter to the violator that they are violating terms of their permit, which permit provisions they're actually violating, where the violations are occurring. And if you're not able to resolve those claims within 60 days, then citizens are allowed to file suit. One of the things you have to be aware of, in addition to standing all the other things that go along with the citizen suit provisions, including notice, is that your violation has to be continuing at the time that you issue the notice letter. In some jurisdictions, maybe all the way up until the time you actually go to trial. most would argue that it's the time you file your complaint. And the precedential decision there is Gwaltney versus Smithfield. Chesapeake Bay Foundation brought action against them for discharges in the area of Southern Virginia that discharged into the Pagan River and from its hog operations down there. What people don't recognize is that, yes, we had to prove continuing violations. We were able to do that, and we actually were successful in getting Gwaltney and Smithfield to install controls and pay a penalty belonging to the state of Virginia. So I know I went through that pretty quickly. Folks may have questions, but that's pretty much it for me.
Thank you very much, John. And we've been receiving a lot of really good questions. I've been answering a few of them as I can through there, but there are also a lot of great questions that we'll get to in the Q&A, and I think answers that will be helpful for everyone to hear. But recognize we may not get to all of them. I'm trying to help address those that I can. So without further ado, I would like to now hand it over to Kelly. So Kelly is a senior attorney at the Southern Environmental Law Center, or SELC, and leader of SELC's Clean Water Defense Initiative. She is entering her 4th year with SELC after practicing environmental law as an associate and then partner in Perkins Coie's Seattle office. Prior to that, Kelly was a trial attorney in the United States Department of Justice's Environmental and Natural Resources Division and served as a law clerk in the United States District Court for the District of Columbia for the Honorable William Benson Bryant. Kelly earned her law degree with honors from Georgetown University Law Center and her undergraduate degree in psychology from Wake Forest University. She is licensed to practice in Washington State and in North Carolina. Kelly, the floor is yours.
Great, thank you so much, Adam. And hi, everybody. Thanks so much for tuning in today. And thank you to ELI for inviting me. A little bit more about SELC. SELC is a nonprofit environmental law firm, and we represent conservation and community organizations. We are engaged in litigation over the definition of waters of the United States. So I wanted to offer that perspective before getting started, because the topic of my my presentation is the waters of the United States under the Clean Water Act. As John mentioned, he packed in material that he covers in a 12-week class in 40 minutes. I am also going to be trying to pack in a topic that has filled volumes of litigation briefs, court decisions, law review articles, and other types of publications. So I recognize that I'm going to be providing a pretty high-level overview of waters of the United States, but hopefully it'll touch on some points and help orient you to the importance of the term and how it evolved over time. So I will be talking about why waters of the United States matters, discuss the evolution of the meaning of waters of the United States over time as it's been defined by agencies. I'll discuss where we are today, the fact that the waters of the United States is currently defined under the prior administration's Navigable Waters Protection Rule. And then I'll touch on what's next to give you an overview of the litigation challenging the rule, and then talk a little bit about what we might expect from the Biden administration. So why does waters of the United States matter? You may have gleaned some of this from John's presentation, but the term waters of the United States is a threshold term in the Clean Water Act, and it defines the geographic scope of the act. The Clean Water Act's regulatory programs apply to navigable waters, which Congress defined as waters of the United States. So the statutory term is the jurisdictional linchpin for all the critical water safeguards that John provided an overview for you just a few moments ago. Waters of the United States also matters because it defines which waters, wetlands, streams, and other waters receive federal clean water protections under the Act. And the Waters in the United States extends to a number of different types of waters, but while we go through the evolution of the rules and case law, much of the evolution relates to which wetlands and which streams are covered. So much of my presentation is going to focus on those two types of waters. As EPA has acknowledged, wetlands matter to the integrity of our nation's waters. They filter pollutants and improve our water quality. They prevent nutrients from flowing in and causing the algal blooms that John described in his presentation. They are natural sponges and absorb and slow floodwaters and reduce damage from storms like the hurricanes that we have been seeing in the last several years in the Southeast. They protect our coast against erosion. And then wetlands within and downstream of urban areas also guard against sedimentation and surface water runoff. They're sort of like biological supermarkets. They contain all sorts of food and attract fish and other animals, and they provide habitat for bird, fish, and other species. Wetland marshes also recharge groundwater supplies, and wetlands store carbon in their plants and in their soil rather than releasing it into the air as heat producing carbon dioxide. So as EPA has acknowledged, streams also matter. Streams including headwaters, intermittent streams that flow seasonally, or ephemeral streams which flow in response to precipitation, they all provide many benefits. Like wetlands, they protect against floods, filter pollutants, and provide food and habitat for fish, birds, and other animals. They are critical to maintaining the quality of our drinking water, and they transport water, sediments, nutrients, organism, and also pollution to the waters downstream. And our biggest rivers are only as healthy as what flows into them. So having a definition of waters of the United States that provides adequate coverage for wetlands and streams is critical for the protection of our nation's waters. So when the Army Corps of Engineers decides whether or not they're waters of the United States on a project site, they memorialize that decision in what's called an approved jurisdictional determination. Those jurisdictional determinations are generally good for 5 years, and they create a safe harbor during which the jurisdictional wetland non-jurisdictional wetland or stream can be destroyed without coverage of a Clean Water Act permit. By that time, even if the waters of the United States definition changes, the damage may have already occurred, the wetland or stream may have already been destroyed, and sometimes the result could be irreversible. So the scope of waters of the United States has, including wetlands, has been the subject of which waters have been the subject of Clean Water Act has ebbed and flowed for the last several decades with the changes of administration and in responses to Supreme Court cases. The Clean Water Act itself does not further define navigable waters or waters of the United States. Congress left further clarification of those terms to the agencies to be interpreted consistent with the objective, the text, structure, and purpose of the Clean Water Act. The EPA and the Army Corps of Engineers have defined WOTUS by regulation since the 1970s. So today I'm going to focus on the key rulemakings that define waters of the United States over time. I'll touch on the 3 key Supreme Court decisions that have affected those rulemakings: United States versus Riverside Bayview Homes, Solid Waste Agency of Northern Cook County versus United States versus Swank, and Rapanos versus United States. I'll also touch on the agency guidance documents that were created in response to Supreme Court decisions. And then I'll touch on the Biden administration's own plans for waters of the United States and their announcement that they will also initiate rulemaking to redefine the terms. So we're going to take a step back, and John mentioned the Rivers and Harbors Act of 1899. So before Congress enacted the Clean Water Act, federal regulation of our nation's waters rested with the Rivers and Harbors Act of 1899. The focus of that statute was and remains navigation and preventing obstruction of navigability of waters. The statute's definition of navigable waters of the United States is driven by that focus, and under that statute, navigable really means navigable. In order to be a navigable water, the water had to be currently used for transport, previously used for transport, or potentially used for transport in interstate or foreign commerce. This definition defines the waters that you're going to hear me refer to as traditional navigable waters, and as that term has been used in Waters of the United States rules and in Supreme Court cases. So in the Army Corps of Engineers' earliest attempt at defining waters of the United States, they limited that definition to traditional navigable waters only, consistent with the Rivers and Harbors Act. The National Resource Defense Council and other environmental organizations thought that interpretation was too narrow, and they sued the Corps in the DC District Court. In the 1975 Callaway decision, the District Court agreed that jurisdiction under the Clean Water Act is not limited by the traditional test of navigability, and that Congress intended the jurisdiction under the Clean Water Act to be extended to the maximum extent permissible under the Commerce Clause. In response to the Callaway decision, the Corps amended its regulations to significantly broaden the definition of waters of the United States, consistent with the Act's water quality protection purposes of the Clean Water Act, as opposed to the navigability goals of the Rivers and Harbors Act. The agency in turn adopted a Waters of the United States definition that included not only traditional navigable waters, but also wet tributaries to those waters and wetlands that were adjacent to those waters. With these regulations on the books, Congress amended the Clean Water Act. And after much debate in both chambers of Congress, Congress did not change the scope of navigable waters or waters of the United States. They did not undercut the Corps' its more expanded definition of waters of the United States, and they, in essence, acquiesced to that more expanded definition. In 1982, the Corps refined its regulations, but did not significantly expand jurisdiction. At that time, however, the Corps added some exemptions to waters of the United States, exemptions that remain today. For example, the exemption that applies to normal farming, silviculture, and ranching practices, and the exemption that applies to waste treatment systems. These rules were challenged in federal court when the Corps applied them to wetlands that were adjacent to other waters of the United States, which resulted in the Supreme Court's decision in Riverside Bayview Homes. In that case, a housing developer began placing fill in preparation for construction in 80 acres of wetland marshes near the shores of Lake St. Clair in Michigan. The Corps retained an injunction in federal district court, and the Sixth Circuit Court of Appeals reversed because the wetlands did not receive flooding from the waters of the United States and nearby navigable waters. In a 9-0 decision, the Supreme Court reversed and agreed with the Corps' assertion of jurisdiction over the wetlands that were adjacent to Lake St. Clair. Recognizing that the term navigable as used in the Clean Water Act is of, quote, limited import, the court describes its decision as being compelled by the language, policies, and history of the act. This was the court's first enunciation of what would later be referred to as the significant nexus test, whereby the Corps appropriately asserted jurisdiction over wetlands that have a significant effect on water quality and the aquatic ecosystem. In 1986, the Corps recodified its Waters of the United States definition without making any substantial changes to the rule language. However, in the preamble to the rule, the agency, quote, clarified that waters of the United States also covered waters that were used as habitat by migratory birds or that cross state lines or by migratory birds protected by migratory bird treaties and other uses. The Corps' basis of jurisdiction on this migratory bird rule was an issue in the next Supreme Court case, Solid Waste Agency of North Cook County versus United States, which is often referred to as SWANK. Here, the Solid Waste Agency wanted to build a waste facility on an abandoned sand and gravel pit in northern Illinois. The pit was not navigable, it did not cross state lines, and it wasn't adjacent to another jurisdictional water. It is what has sometimes been referred to as a geographically isolated water. The Corps asserted jurisdiction over the pit and denied the application for the Clean Water Act permit. And the district court agreed with the Corps, and the Seventh Circuit affirmed. In 2001, the Supreme Court reversed in a 5-4 decision. The Corps rejected the Corps' assertion of jurisdiction because it rested solely on the fact that the pit had been used by migratory birds as habitat. But that by itself was not enough. Through the decision, the court invalidated the migratory bird rule and again emphasized that it was a significant nexus between the wetlands and navigable waters that informed our reading of the Clean Water Act in Riverside Bayview homes. That nexus was not found in the SWANK case. After the SWANK decision, the EPA and the Corps issued a joint memorandum instructing field staff that they should not assert jurisdiction when the sole basis is the migratory bird rule. The memo also instructed that field staff should seek headquarter approval prior to asserting case-by-case jurisdiction over geographically isolated wetlands on ties to interstate commerce. Jurisdiction otherwise remained largely constant. So as we move into the 2000s, the agency started to focus more on science, and we started to learn more about what it means for there to be a significant nexus. So the next case is the most recent and probably the most written about. Rapanos arose from 2 consolidated cases: an enforcement action against John Rapanos for filling, ditching, and draining 54 acres of wetlands in Michigan to build a shopping center and residential homes without a Clean Water Act permit. The wetland parcels drained into several rivers and ultimately into Lake Huron. The second case was a challenge by Keith and June Carabell to the denial of a Clean Water Act permit to fill wetlands that were 1 mile from and flowed into Lake St. Clair for a housing development. That's the same Lake St. Clair that was at issue in Riverside Bayview. In both cases, the Corps asserted jurisdiction over the wetlands at issue, not because they were adjacent to traditional navigable waters, but because they were adjacent to tributaries, non-navigable tributaries to traditional navigable waters. In both cases, jurisdiction had been upheld by the district court and the Sixth Circuit. And in a fractured opinion, the court vacated the lower court decisions and remanded for the Corps' reevaluation under the 1980s regulations that we've just discussed and the jurisdictional test announced by the court. The court announced 2 jurisdictional tests. First was Justice Scalia's plurality, joined by Justices Roberts, Thomas, and Alito, which covered only 1, relatively permanent waters connected to traditional navigable waters, and 2, wetlands with a continuous surface water connection to those waters. The second test was articulated by Justice Kennedy and built on the significant nexus test that was announced in Riverside Bayview and in Swank, whereby jurisdiction extended to non-adjacent wetlands or geographically isolated wetlands that have a significant nexus to a traditional navigable water. For wetlands to possess the requisite nexus, they either alone or in combination with similarly situated wetlands in the region significantly affect the integrity of traditional navigable waters. So although the four dissenters would have affirmed jurisdiction, they agreed with Justice Kennedy that the plurality opinion was inconsistent with the text, structure, and purpose of the Act. Every court of appeals to consider the issue has held that waters that meet the significant nexus test are waters of the United States. No court or no federal court of appeals has found that the plurality test is a sufficient test in and of itself for the basis for extending jurisdiction. So following Rapanos, the agency issued more guidance to apply the decision on the ground. Under that guidance, waters of the United States includes traditional navigable waters, wetlands adjacent to traditional navigable waters, and waters that satisfy either the Rapanos plurality test or the Justice Kennedy's test. Under the guidance, however, for waters to have a sufficient flow under the plurality test, they must typically flow year-round or have continuous flow, at least seasonally, which is typically about 3 months. And to assess whether a wetland meets the significant nexus test, the agencies consider both the flow characteristics and functions of the adjacent tributary and the functions performed by all wetlands that are adjacent to the tributary to determine if they significantly affect the integrity of the downstream traditional navigable waters. So this case-by-case analysis remained until 2015, when the agencies attempted to clarify the Clean Water Act in adopting the Clean Water Rule. So the Clean Water Rule was the result of a 4-year rulemaking process, during which the agencies compiled an empirical record that was consolidated in the connectivity report or the science report, which incorporated more than 1,200 peer-reviewed publications on the connectivity or isolation of streams and wetlands and how those connections impacted traditional navigable waters. They used this record to determine which waters satisfy the significant nexus test so as to warrant their inclusion as waters of the United States. The rule identified 8 categories of jurisdictional waters. The first 3 have been regulated throughout all regulations: traditional navigable waters, interstate waters, including interstate wetlands, and territorial seas. Any impoundments of those waters or tributaries of those waters are also waters of the United States. For the first time, the Clean Water Rule defined tributary. Under the rule, a tributary was defined as a water that 1, contributes flow either directly or indirectly to another water through another to a traditional navigable water, or 2, has physical indications of flow, a bed or banks, or an ordinary high water mark. Under the rule, the term was broad enough to include intermittent and some ephemeral streams. Now, the prior regulations included wetlands that were adjacent to other waters of the United States and defined adjacent to include bordering, contiguous, and neighboring. The Clean Water Rule instead included adjacent waters as opposed to simply adjacent wetlands, and defined waters as neighboring based on distances between those waters and other jurisdictional waters, features such as the ordinary high water mark, the 100-year floodplain, and the high tide line. While the prior waters of the United States regulations included intrastate waters with ties to interstate and foreign commerce, the Clean Water Rule eliminated that category of waters. However, some of the waters that may have been included in that category might have still been regulated under the Clean Water Rule because the rule included a category of regionally important wetlands, so-called geographically isolated wetlands, prairie potholes in the upper Midwest, Carolina and Delmarva Bays in the Atlantic coastal plain, Pocosons in the Atlantic coastal plain, western vernal pools in parts of California, and coastal prairie wetlands on the Texas Gulf Coast. These wetlands were waters of the United States if they were determined on a case-by-case basis to have a significant nexus. While the decision must be made on a case-by-case basis, the rule clarified that For the purpose of that analysis, the wetlands were similarly situated and should be combined with all others like it in the watershed in making this significant nexus determination. So the photo on this slide is a photo of prairie potholes in the prairie pothole region, which extends predominantly through Montana, the Dakotas, Minnesota, and Iowa. This area is also called the duck factory because prairie potholes provide habitat for up to 3/4 of North America's breeding ducks. Now, the Clean Water Rule was challenged by coalitions of states, and industry, Farm Bureau, and courts across the country. It was also challenged by some environmental organizations as not being broad protective enough. It was eventually preliminarily enjoined in several states, and then 2 courts found the rule to be unlawful under the Administrative Procedure Act, or at least aspects of the rule to be unlawful, and remanded the rule to the agencies without vacating it. So that brings us to where we are today. And currently, Waters of the United States is being defined under the Trump administration's Navigable Water Protection Rule. And as I mentioned, SCLC is representing clients in court challenging this rule. So just after taking office, President Trump issued an executive order in 2017 instructing the agencies to review the Clean Water Rule for consistency with the administration's policies and consider interpreting the term navigable waters consistent with Justice Scalia's plurality opinion in Rapanos. In July 2017, the agencies responded by proposing to repeal the Clean Water Rule and reinstate the 1980s regulations as informed by the Swank and Rapanos guidance as the first step in a 2-step rulemaking process intended to repeal and replace the Clean Water Rule. Meanwhile, in 2018, the agencies attempted to delay the effective date of the Clean Water Rule and reinstate the pre-2015 regime, the 1980s regulations as informed by the Swank and Rapanos guidance. But that attempt was ruled unlawful by 2 courts, including a court presiding over our challenge to that rule. The agencies finalized their repeal of the Clean Water Rule in October 2019, reviving the 1980s regs as informed by the Swank and Rapanos guidance. But on April 21st, 2020, the agencies published the final Navigable Waters Protection Rule, which adheres to the Rapanos plurality and openly rejects the court's significant nexus test. So most of my focus has been on wetlands and streams, but there was one change in the Navigable Waters Protection Rule that was pretty striking. So for the first time under the rule, traditional navigable waters, or otherwise jurisdictional waters, including traditional navigable waters, were excluded if they also fit within the rule's exclusions. The rule also expanded the waste treatment exclusion, such that all waters that are used as cooling ponds are excluded from Clean Water Act jurisdiction, even if they are traditional navigable waters used for drinking water, public recreation, and in interstate commerce. With these changes, public lakes like the one you see here, Lake Huey in South Carolina, fall outside the Clean Water Act because they were created to provide cooling water for industrial facilities. Lake Huey here helps cool Duke Energy's 3 nuclear reactors located at the Oconee Nuclear Station. The lake is also a popular recreation spot, vacation spot, and provides drinking water for 400,000 people in South Carolina. In adopting the Rapanos plurality emphasis on permanent flow, the Navigable Waters Protection Rule categorically excludes ephemeral streams, waters that flow in response to precipitation. In their rulemaking documents, the agencies acknowledge that the focus on flow and permanent flow would mean that even some intermittent and perennial continuous flowing streams could be out. The agencies estimated that up to 70% of the nation's streams lose protection under the rule, even closer to 90% in the arid West, where rivers like the one you see here pictured flow after a big rain. So the Navigable Waters Protection Rule also restricts wetland protections, emphasizing the need for the wetland to either touch or have a permanent surface water connection with the jurisdictional water. The rule also includes wetlands that are inundated by a waters of the United States, but does not include wetlands that flow into a waters of the United States. The agencies estimated that over half of the country's wetlands would lose protection under this rule. And the regionally important wetlands like the duck factories, prairie potholes, which are pictured here, are largely no longer protected. So in the agency's economic analysis evaluating the impacts of the Navigable Waters Protection Rule, the agencies acknowledged in text and in this graphic that the rule could diminish stream flows, water quality, drinking water supplies, and endangered and threatened species habitats. They also anticipated increased dredging and filling of streams, increased flooding, degraded aquatic and wetland habitats, greater pollutant loads, increased sedimentation, and harms to drinking water supplies. The rule was effective on June 22nd, 2020. And according to EPA's data on its website, the only publicly available data that we've been able to identify, 92% of the waters considered under the rule have been found not to be jurisdictional. Now, there are a number of striking examples where waters have lost jurisdiction under this rule, but one of the most striking reversals relates to a proposed titanium mine at the doorstep of the Okefenokee Swamp, the largest intact freshwater ecosystem in North America. The proposed mine would excavate hundreds of acres of wetlands to a depth of 50 feet. After the Navigable Waters Protection Rule went into effect, the mining company sought a new approved jurisdictional determination, seeking a reconsideration of the jurisdictional nature of the wetlands on site, given the scope of the current rule. And the Corps reversed course on nearly 400 acres of wetlands previously protected. Now, the only possible protections for these wetlands rest with the state of Georgia, which is already constrained by resources and other limitations. So now, moving to litigation, there are 15 cases challenging the rule across the country. As I mentioned, SELC has a case pending in South Carolina and another pending in the District of New Mexico. The Chesapeake Bay Foundation, John's organization, has a case also pending. And other cases have been brought by other environmental organizations, tribes, and a coalition of states, alleging that the rule is too narrow and it violates the Administrative Procedure Act and undercuts the objective of the Clean Water Act. There are also several cases that have been brought by industry and the Farm Bureau that argue that the rule is too protective. Now, when the Biden administration came in, it needed time to evaluate the Navigable Waters Protection Rule and to determine its litigation position in all these various cases. So many of the cases were stayed while the agencies reviewed the rule and figured out their litigation position. As of today, there are 5 cases still moving forward in hopes of getting a court decision regarding the lawfulness of the rule. The agencies under the Biden administration have announced that they will be seeking a voluntary remand of the rule, keeping it in force while they undertake their own Waters of the United States rulemaking. So that brings us to what's next. On June 9th, 2021, the agencies announced their intent to initiate a new Waters of the United States rulemaking process that restores the protections that were in place prior to the 2015 Clean Water Rule and develops a new rule to establish a durable definition of waters of the United States. Now, Administrator Regan has gone on record saying that he does not anticipate the agencies would return to the 2015 Clean Water Rule, but instead the agencies would take the lessons learned from that rule and the Navigable Waters Protection Rule and all other prior iterations of waters of the United States in crafting a new rule that could survive judicial review and is consistent with the objective of the Clean Water Act, Supreme Court precedent, and science. When the agencies made their announcement about their intention to initiate this new rulemaking, they announced that their review of the Navigable Waters Protection Rule had been completed. And based on that review, they found the rule is significantly reducing clean water protections and leading to significant environmental degradation, consistent with the prior administration's own forecasts. In that announcement, the Biden administration also acknowledged that these harms that we're seeing are particularly significant in arid states like New Mexico and Arizona, where apparently nearly every one of over 1,500 streams assessed has been found to be non-jurisdictional under the rule. In their announcement, the agencies also cited at least 333 projects that would have required Section 404 permitting prior to the rule, but no longer do so, meaning that no waters of the United States are found on those project sites. That number does not capture all the other project sites where a majority of the waters have lost protection, but still require a permit for a much smaller area. And finally, in their announcement, the Biden administration acknowledged the serious risk posed to the Okefenokee Swamp. So time will really tell whether or not waters of the United States will continue to evolve and whether this administration can promulgate a durable rule consistent with Supreme Court case law and the Act. For that, we'll have to stay tuned. So thank you very much.
Thank you, Kelly. And John, if you're able to come back in and join us, we'll get to the question and answer session, which will be a doozy. There are some really great questions in here. I want to start by saying that the slides, or there was a question about whether the slides would be available, and they are going to be available on the event page for this program. So if you check back later, you will be able to access these slides. All right, jumping into the deep end here. Kelly, I'll start with a few questions for John. That way, if you have time to kind of go through some of the questions that are there, you'll have, won't be catching you by surprise on some of these. So John, to start, you had mentioned cooperative federalism when you were talking about states having the opportunity to be more stringent in some of their requirements. And the question was, how does that interact with the Dormant Commerce Clause principle?
Taking me back to law school, Dormant Commerce Clause provision. But I think that the concept of cooperative federalism, you know, it arose pretty directly in the Bay TMDL case, because the Farm Bureau argued that EPA's action in developing the Bay TMDL overrode the authority of the states to protect their waters. And look, here's the Clean Water Act specifically calls this out and says you got to be cognizant of states' rights here, but you're not doing it. And what we're finding is that you know, the Trump administration tried to rely on this concept of cooperative federalism and have all the things it did, but it from our view, typically overrode states' rights in a lot of cases. So the kind of unique thing for the Chesapeake TMDL and cooperative federalism concept there is that the states actually asked EPA to develop this TMDL because they realized that they could not address all the sources of pollution by themselves, and that unless it was a collective multi-state and DC decision and actions, that it wasn't going to happen, and that only EPA had the authority to kind of direct each of them. You know, you're not issuing proper point source permits. You're not addressing a provision what's called anti-degradation. You're degrading existing water quality, and you're not complying with local total maximum daily loads for your own streams and rivers for those sections that are impaired within your own jurisdictions, for example. So EPA has that authority to actually direct the states to do more. And as I said earlier, if it's not, for example, if the state's not living up to its obligations under the point source provisions of the Act, EPA can withdraw that delegation and take back that authority, something we're asking it to do if it can't, for example, get Pennsylvania on track with respect to meeting the Bay TMDL provisions. So I'm not certain if this directly answers the question, but for us anyway, we believe that cooperative federalism is one of these really important things to recognize, but to not overlook the fact that the Clean Water Act was written because Congress recognized the inability of states to always protect their own water quality, or be unable to do that for a variety of reasons, like trying to develop their economies by attracting more industrial sources of pollution, and therefore not maybe coming up with a more stringent permit limitations that it should have, and that EPA needs to have that oversight authority in that circumstance, for one example.
So going back to law school and some things you might not, and I hadn't thought of since then, a question on how do interstate compacts regulating basins like the Delaware River Basin Commission or the Upper Colorado River Commission coordinate or supersede the Clean Water Act and the EPA?
Yeah, I know for the Bay, there is a separate Chesapeake Bay agreements, and we had, I think it's 4 or 5 of them now. And as I mentioned earlier, Section 117G of the Act actually identifies those those Bay agreements. As I said, there have been several, and so that those do have control, because Section 117 directs EPA to actually make certain that management plans are developed and implemented. Implementation is begun and we would say completed, because you can't meet the water quality standards, for example, that are in the Bay Agreement without complying with the Chesapeake Bay TMDL. With respect to those other commissions, I don't know whether there's a specific statutory provision directed to those. I know there are some for the Great Lakes, for example. And one of the arguments I made when we sued EPA back in 2009, we said, well, these are actually interstate compacts. Now, traditionally, that deals with the actual water quantity issues. Can one state withdraw more water from the Colorado River than another, for example? And Congress has ratified those compacts. So we argued that the Chesapeake Bay Agreement was actually an interstate compact because it was ratified by Congress through Section 117G. We never had to litigate that issue, but I think it's out there. I think it could carry over for those other commissions, Delaware, for example. But I know courts are cognizant of those decisions as well. For example, in those 401 certification decisions, they recognize that the states have bound themselves to complying with provisions of those compacts. So they do carry some weight.
Yeah, I think if I were to add anything to that, I would just say, sort of as John was alluding to, it depends. It depends on the compact you're talking about. I know that's a very lawyerly answer, which you're probably going to get from us, but it depends on the contact, the terms of the compact, and what the compact is covering. I mean, obviously, most of the compacts in this interstate compacts in this country are water quantity, water allocation issues. And in my experience, in terms of that water quantity and water quality nexus or divide, if you will, generally they try to avoid each other to the extent possible. Play is somewhat nicely together, but it is a very difficult area to navigate. But yes, it's a really phenomenal question. Wanted to get into, there's a question about, there are 2 of them actually, about agriculture. So one was, please discuss agricultural pollutants, and they use the term pollutants. So I think we can kind of differentiate or highlight some of the things that may come off of ag lands that are of particular relevance to talk about here. But they noted point source, CAFOs. And so I think there's also some question here about that distinguishing the non-point source and the point source. There's also a question as to why ag stormwater discharges are not considered to be point sources, and is anyone pursuing the change to that? So one of the things I noted to them was that the definition of point source actually has a sentence at the end that states that your irrigated ag lands are indeed not point sources. It intentionally carves them out. But is there anything you'd like to add in terms of ag pollutants and then that non-point source arena and whether there may be any work being done to change that.
Yeah, thank you. And it is kind of a complicated question because you have these conflicting provisions of the Act. So, I know I went pretty quickly through the CAFO part. So, concentrated animal feeding operations are actually defined by regulation, depending upon the number of livestock that you have on your farm. And I've forgotten now exactly what all the numbers are. It's different for cows and pigs and ducks and llamas and horses, everything imaginable. But it has to do with the weight of the animal and the expectation of how much manure they're going to actually produce. And so you can have an animal feeding operation, but not be a CAFO because you don't have the requisite number of animals on your farm. Now, the administrator of EPA, in conjunction with the state where the AFO is located, can actually designate an AFO as a CAFO and require it to have a permit. And no, those permits are typically not telling the farm, well, you got to put a wastewater treatment plant at the end of the discharge point from your dairy farm. What they're asking them to do is to come up with ways in which they can control the amount of manure they spread, because typically what happens is the manure has a lot of nitrogen in it, and so it can be used as a fertilizer. The problem for most places within the Bay region anyway is the over application of that manure, and so you then have runoff nutrients, more nitrogen, and in some circumstances phosphorus, and of course sediment, because cattle stomp down stream banks, for example, because they're not fenced out of streams by the particular farmer, and the state has not decided to actually require the exclusion of livestock from that waterway. So now we have animals directly defecating into bodies of water as well as degrading the bank that all contribute to pollution within that body of water. So there are a lot of different issues associated with CAFOs. A new case that just came out of Montgomery County, Maryland Circuit Court, in which the Chesapeake Legal Alliance brought a lawsuit against Maryland's general permit for CAFOs within the state of Maryland, saying that they neglected to regulate ammonia that's coming from the manure that's generated by these CAFOs within the state of Maryland. That decision is being challenged to the Maryland Court of Special Appeals, so it'll be pretty interesting to see how that all irons itself out. And no, there doesn't seem to be any movement afoot to try and get those agricultural limitations within the statutory provisions of the Act changed. I think most people would recognize that the ability of Congress to make a decision like that would have had to have come back in the 70s or something, where it should have happened, and Congress could actually work together to generate some pretty amazing environmental statutes, but that's not the climate we live in today.
Kelly, I'll ask you a question or two in a minute, because I want to make sure these aren't all John and then all you. But I ask two more of John real quick before we'll get to some questions for you. And so you can pick some of your favorites to address if you'd like. Sorry I didn't offer you the same thing, John, yet. So two quick questions that I'll answer. One, are there any states that EPA has not delegated NPDES permitting authority? The answer is there are three: Massachusetts, New Hampshire, and New Mexico. And the other question was, which states have been delegated 404 authorities? And those are there three of them: Florida, Michigan, and New Jersey. So quickly on that front, staying on the 404 topic, there were a couple of people that asked why the Secretary of Army is involved in the discharge of dredged material permitting, and why not as a non-military agency, or why the EPA doesn't have control over that. John, do you want to tackle that?
Yeah, I think this is kind of a carryover from the Rivers and Harbors Act, where the Army Corps was actually controlling all of the decisions there with respect to operations, navigable bodies of water. And as we mentioned early on, one of the sources of pollution is dredge spoil, and the Army Corps was traditionally one of the dredgers, so that they have a lot of experience in that area, and so the statute just kind of followed on the Army Corps' authority and familiarity with that kind of operations within actual navigable bodies of water.
Great. So last one before Kelly. So it's a question that had two parts, because I want to make sure I understood it. So the question was purposely left off tribes and territories. Is tribes as states a continued legal term under the language of the Clean Water Act? My quick answer to that was that it's referred to usually as treatment in a similar manner as states at this point. And the follow-on to that was looking for a little clarity. He was looking for tribes' development of Clean Water Act or water quality standards and ability to permit as states within their jurisdiction. Often when speaking of federal law and its relationship to states, the discussion frequently adds tribes and other territories, giving legal credence, but there may be a reason for leaving them out of the discussion in this case, and perhaps addressing the legal framework in a separate presentation. So with regard to that state tribal, I quickly answered him to say that, to my knowledge, 50 states currently have TAS for standards, or roughly 50 tribes. Last I knew it was 49, and that was a few years ago. But is there anything you want to add to that in terms of tribes and territories in terms of how they fall in with the Clean Water Act?
Yeah, I think there's also the recognition, and it sounds like you might know more about this because we typically don't deal with tribal issues too much in the Bay region, although Virginia has now identified, I think it's 7 more tribes. So that may be changing here shortly, but it certainly is an environmental justice issue that we've been paying attention to. And I think you may have seen from the King William Reservoir case that there were tribe resources that were being affected. So what we typically see is the tribe participating in public notice and comment and identifying impacts to its resources and the cultural importance of preserving water quality for the tribes. I think the statute and Congress may have recognized there could be competing interests between a tribe that's within a state designating tribal waters to a different standard than the state does. And if I remember correctly, there actually is a case going on right now about that, in which the tribe tried to designate a better quality, water quality standard for the stretches of the river that ran through tribal lands.
No, there's no question that there are some challenges there, and it's one of the reasons that some tribes are very interested in getting that treatment in a similar manner so that they can develop their own water quality standards and are more or less treated as other jurisdictions. And there is that opportunity for laying down those baselines of these are our standards for our waters. One of the challenges that a number of tribes face is that they don't really have the resources to run these programs, and many of them are quite intensive. And it's one of the things that so far there is now the opportunity for tribes that have been for about 3 years to get the authority to list waters that are impaired and to develop TMDLs. No one has applied for it yet, but my understanding is that several tribes are interested in it. But it's highly resource intensive, and it's one of those things that's sort of trying to weigh the balance and the expense to them. The benefits and the expense to them is one of the big things that they have to work on. The Fond du Lac tribe of Lake Superior, Chippewa, is one that has water quality or TAS for water quality standards, and I believe has been authorized 404 authorities. Is the only state in the country to have that. And so they put a lot of resources into their water quality protection and are a pretty good example if you're interested in sort of seeing what has been done in a tribe from a tribe that is really active in this area. They're a great example. With that, Kelly, do you have a question or two you'd like to address, or do you want me to tee them up for you?
Either way works for me. I looked through the questions. There are a couple I could just knock off the list real quickly. So there's one question, just how many states control their Section 404 programs or have assumed a 404 program? There aren't very many. Just Michigan, New Jersey, and Florida just recently assumed 404 program this past year. A number of other states have evaluated whether or not it makes sense for them to do this, and most of the states that have evaluated have determined that it's cost prohibitive. They just lack the resources and expertise. They lack the staff to run, the 404 program. So, it is something that states consider, but they would have to make their state laws, bring their state laws consistent with federal regulation. It's just, so a lot of them who have considered it have ruled it out. The other question that I can probably cover pretty quickly is whether or not vernal pools are waters of the United States. And I think the answer is it depends. They are, typically ephemeral, or they have they're wet in response to precipitation, or they have seasonal water in them. But even though they provide critical habitat and they are considered by ecologists to be very valuable wetlands with wetland functions that benefit the aquatic ecosystem, it really depends on what definition of waters of the United States you're looking at. So under the current rule, it's unlikely that they would be jurisdictional, given the fact that to be jurisdictional, they would have to have a continuous surface water connection with another jurisdictional water in a typical year. And so it's a test that rules out a number of wetlands like vernal pools that, although have really critical wetland functions, don't have that continuous surface water connection required under the Navigable Waters Protection Rule. Under prior rules, it's an open question, and it depends on some site-specific information, but I hope that answers the question on that. And let's see.
I can pose another one while you more. So what is the FERC's jurisdiction and function related to the Clean Water Act? Is it involved in relation to hydropower? I don't know if we want to get into 401 certifications or there's anything else. And by the way, for those of you who may not know, FERC, if I remember correctly, is Federal Energy Regulatory Commission. Any comments from either of you in terms of FERC's relation to this world?
I could just mention sort of FERC's, it kind of falls into your bailiwick and your presentation, John, but I'll just quickly say, 401 certification is required for any federally licensed or permitted project. And FERC is one of the federal agencies that issues licenses. It issues licenses for dams and constructions related to dams, which last for over 30 years in some situations. And where that dam would result in so right now, the definition of waters of the United States has been repurposed by the prior administration, the Navigable Waters Protection Rule. The prior administration also revised the 401 certification rule, which gives states the authority, as John mentioned, to impose conditions on large projects like dams that to ensure that the water quality within their borders is protected. So FERC is one of the agencies that issues those licenses or permits that triggers that 401 certification authority. With the current 401 certification rule and states having very limited, states having their authority curtailed under the 401 section or the 401 certification rule, it's really problematic because those the states are just unable to impose the types of conditions necessary or get the information necessary the information that they need to make those decisions under the current rule. And if they aren't able to do that and protect their water quality or waters within their borders, project dams that are licensed for 30 years can go on degrading the water quality within those states.
Yeah, just real quickly, Adam, we spent a lot of time dealing with the Atlantic Coast Pipeline 401 certification in the state of Virginia, and now also, I guess, SVLC and others have participated in the Mountain Valley Pipeline. And what we saw there were states attempting to put controls on or limitations on the construction of massive pipelines, over 400 miles in the Atlantic Coast Pipeline, and through mountainous region across major rivers or under major rivers. And because of the steep terrain in which they were doing this construction, FERC said, okay, we're going to accept Virginia's conditions, but turns out those conditions weren't sufficient. And we saw some disastrous effects to some major and well-recognized trout streams in a lot of these high mountain areas in the Blue Ridge, for example, or in the Appalachians, just devastated by the sediment runoff by these sites. So yeah, FERC has to rely on the states to be able to identify these problems. And when the states aren't able to do that or don't do that, I mean, all you're really left with are citizen suits, which are difficult to win. So it's been tough. There seems to be some changes. We were kind of hoping that FERC was actually going to take more of a leadership role in saying, wait a minute, this doesn't look like a good project for this area. But that's not what it's really designed to do. It has to primarily rely on the expertise of the states and oftentimes information that are given to it by other federal agencies or given to it from citizens groups.
All right, I'll throw a quick question out there because I have to admit this one stumped me. And I work with the TMDL program all the time. If the EPA develops the TMDL rather than the state develops the TMDL, who pays?
Yeah, I am not aware that the state sends a bill or EPA sends the state a bill. EPA is pretty much directed to do it, and it's done so by Congress, and so it's part of its budget, is my understanding.
That's my understanding as well, but I wasn't confident in that answer, so thank you. Another question concerns 402 permitting, and basically there are actually a couple of these questions of what's the process? What are people looking for when they're reviewing a permit? What is likely to trigger a permit being denied? I know that may be, again, sort of it depends type of answer, but are there any sort of generalities there that you could provide or talk about?
Yeah, I mean, it's I'll start off with this, and I'm going to admit it's my bias, but I saw it happen when I was at DOJ as well, is that some states are not always that protective of their own water quality, sad to say, and you kind of need the backstop authority of EPA to take a look at the permit to make certain that it actually is going to be protective of water quality, or of citizens to actually, have some information of their own or provide their own expertise or experts to challenge a decision to grant a permit like that. So the process, is first off a bureaucratic one within the state agency if it's delegated authority to do that. And then the state puts the permit out for public notice and comment, and it's up to the citizens to point out deficiencies in the permit terms, deficiencies that are actually going to harm water quality or not keep it at its existent quality. So once that process is gone through and the permit is issued, and again, my experience has been that we've seen most states kind of see their obligation of permit authority as one of which they have to help the customer, which is the applicant, when we feel like that what they should be doing is protecting water quality and citizens' rights to clean water, fishable, swimmable. So your only alternative if the permit is issued and it's not going to be protective of water quality is litigation, unfortunately.
Excellent. And Kelly, did you have anything to add?
No.
No, perfect. Were there any other questions, Kelly, that you wanted to address from the list that we had sent?
There was a question that gets into a little bit of the point source question, but one of the questions asked, what are the latest actions being taken by regulatory agencies and organizations like SCLC regarding industry effluent discharges of PFAS and other man-made chemicals? And I just wanted to mention that it's something that we are working very heavily on in North Carolina and in other states. You know, some states that we have brought a number of suits in North Carolina under the Clean Water Act for discharges of PFAS. Because PFAS is a pollutant under the Clean Water Act, and you're not allowed to discharge that pollutant without a Clean Water Act permit. We've also been engaged with a number of agencies to discuss the importance of requiring and mandating that industry discloses their use of those chemicals. And we're seeing agencies start to impose some limitations in NPDES permits, at least with respect to known contaminated sites that are cleaning up PFAS contamination. Some of the permits that we've been seeing come out of North Carolina include some NPDES limits, discharge limits for PFAS, which is promising. You know, we've been urging agencies to impose the technology-based effluent standards under the Clean Water Act. Because there are technologies out there and they're becoming more and more well known that can reduce the volume of PFAS and discharges. And we're seeing states across the country, states across the country start adopting maximum MCLs under the Safe Drinking Water Act. We're seeing states adopt groundwater cleanup levels, and we're starting to see states adopt health advisories and other types of limits that can inform NPDES permitting. And we're continuing to urge EPA to do that. So they have been taking steps recently to kind of expedite the agencies' gathering of information about these chemicals and speeding up their more proactive steps to reduce the discharge of these chemicals.
Excellent. Well, we have about 2 minutes left. I think with the time remaining, I would just like to ask John and Kelly if you both have any final concluding thoughts on the Clean Water Act for our summer school participants. So John, I'll start with you.
Yeah, I think, you know, the act, was great in its development or the beginnings. It had as we saw early on, the policies and goals were, you know, over the moon, I guess, now that we look back on it. And you would think after all this time has gone by, most of these areas would be settled, but they're not. And I think, you know, the one with respect to WOTUS is probably the most notable. It's sad that, you know, Congress hasn't been able to figure out a way to define this once and for all. I think if we just continue to go through the regulatory rulemaking and just, you know, litigation on top of litigation, we won't ever get it resolved. And I think this falls on one of the questions about, you know, the Clean Water Act being decided by courts. No, that's not the way it was supposed to happen. We're supposed to rely on science, and I understand that people can have questions about science, but at the end of the day, I think we have to recognize that most water is connected. We're not, as Justice Scalia said, out to regulate mud puddles, but there is a significant nexus or functional equivalent or whatever you want to call it to most bodies of water. And unless we protect our water, we're not going to be around long.
Excellent. And Kelly, do you have any concluding thoughts for us?
Yeah, I'll just say, I mean, that was great, John. I agree. You know, the statute does have lofty goals, and the goal is rooted in science. I mean, the objective of the act is to restore and maintain the physical, chemical, and biological integrity of the nation's waters. So, you know, I think that continuing to follow science and determining what we need to protect to make sure that our families and communities and kids can have access to clean water and safe outdoors to play in. And that the people out there on the ground who are relying on clean water for their businesses, drinking water utilities, you know, outfitters, breweries, restaurants, you know, and vulnerable communities who are sited closer to industrial facilities, communities that are on the coast that are being hit by storms. These are people who rely on strong clean water protections. And unless we have a strong, durable federal baseline, those communities and those people will continue to suffer. So it's important that in any additional or future rulemaking that science is considered. The rule needs to be rooted in that science, needs to be very thoroughly explained how it connects to the science, and in engaging stakeholders. You know, we're hoping that the administration and agencies will reach beyond folks with a DC footprint, engaging industry, engaging agriculture, that, you know, who are also impacted by the rule, but also opened up that dialogue to hear from the communities on the ground who depend so heavily on clean water for their livelihoods.
Excellent. Well, thank you both so much. I just so appreciate your many contributions to this program, and to Adam as well. Adam unfortunately had to drop off a minute earlier, so but just really appreciate your contributions to this. And also just want to say thank you so much to our participants for joining us today, for your many excellent questions. We apologize we couldn't get to all of them, but really they were all phenomenal. We hope you'll continue to watch this space in the years ahead, and hope that you'll continue to join us for summer school throughout this summer. Please do not hesitate to reach out to me at randall@eli.org should you have any questions. In the meantime, please take care and stay safe. Thank you all so much, everyone.
Bye.
Thank you.
Bye, Kelly.
Bye, John.